I hope the screen is also visible too. Yes?
Yes, sir.
Yes, sir.
Yeah. Okay. Okay. So let us start with the today's topic, everyone. In the today's topic, we have to start with the, I think up to previous topic, we are done with the 4 types of prospectus. All the 4 types of prospectus. Along with that, we are also done with the misstatement of prospectus. I hope you all remember that.
Yes, sir.
Misstatement of prospectus, half disclosure, wrong disclosure, and then we also understood who has to prove that in the court of law. There's a misstatement in prospectus. Any allottee or first allottee, everyone? Who has to prove that in the
First allottee.
yes,
First
first
allottee.
allottee. Yeah, no one else can prove or no one else can file the case. And then if it is proved in the court of law, yes, there is a misstatement in the prospectus, then either the criminal penalty will be imposed or what? Civil penalty will be imposed. I hope all of you understood everything up to this point, right?
Yes, sir.
And when I told you civil penalty, it was compensation with limit or without limit? Without limit. And when I told you the criminal penalty, it was what? Penalty under section 447. Before that, we have also completed the types of prospectus. How many types of prospectus we did yesterday? If I'm not wrong, we did the 4 types of prospectus. One is deemed, one is abridged, one is shelf, and one is red herring. So in the deemed prospectus, we understood company first allot the shares to the issue house. Issue house allots the shares to the public within 6 months. That is called deemed prospectus. Abridged prospectus is nothing but the summary of the already issued prospectus, where the company would like to give the abridged prospectus also to the every applicant, failure of which will draw a penalty of rupees, I think 50,000 rupees per copy undelivered. Yes, everyone? And shelf prospectus, what is the shelf life of this prospectus, everyone? 1 year. During that 1 year, everyone, the company may come up with the n number of issues, but every time, whenever there is a change in the financial position, we have to file PAS2. That is called, yeah, PAS2 we have to file, which will bring the notice to the notice of changes to the ROC. And this is what the shelf prospectus, that is called information memorandum. And last but not the least, red herring prospectus, where we understood that when we know the amount of capital to be raised, but we don't know what, we don't know the price of the share, we don't know the number of the shares. For that, we follow the book building process. And once we get the actual price, we have to file the final prospectus with whom? ROC and SEBI again. And if there is any variation between the two, do we have to give the opportunity to the existing applicants to withdraw their money? Yes or no? Yes,
Yes,
within
sir.
15 days. And after that 15 days, if you are unable to pay, then they will be having, will be having a, what do you say, interest penalty at the rate of 15% per annum. Is it clear to all of you? And
Yes,
then
sir.
we talked about misstatement. Misstatement means 3 things: half disclosure, wrong disclosure, and non-disclosure. Who has to prove that in the court of law? First allottee. And finally, if it is being proved, there will be a criminal penalty or civil penalty. Now let's further move to the next topic. What is the next topic, everyone? Ki how can we escape? Now the next topic is, everyone, how can we means what? Promoters or directors or experts or professionals can escape from civil or criminal liability. Can anybody tell me what is the meaning of this topic, everyone? In case you think that you are a genuine person, in case you think that you are a genuine person, you can apply to the court of law ki, sir, I am a genuine person, I did not do it intentionally. And if the court of law is able to understand your part, and if the court of law finds you no guilty, then in that case, what will be happening? Then you can escape from this particular provision. Are you getting the point? You will neither be liable under civil liability or you will not be liable under the criminal liability. Now, how we can escape from the civil penalty and how we can escape from the criminal penalty, everyone. There are two penalties. How to escape from criminal and how to escape from which one? Civil. Now, how to escape from criminal and how to escape from civil liability. Now, listen to this point very, very carefully, everyone. Very, very carefully. If you want to escape from the criminal liability, you have to prove two things in the court of law. Any of the two things you prove in the court of law, and the judge will simply give you the escapism. Judge will not punish you under section 447. So, point number one, if it can be proved that statement, it can be proved that the statement or consent given is immaterial in nature. What is nature? Immaterial in nature. What do you mean by immaterial, everyone? Ki was my statement relevant or irrelevant? It was irrelevant. Was it important or non-important? It was non-important. Was it significant or non-significant? It was non-significant. If I can prove that in the court of law, ki sir, my consent, suppose I'm an auditor, I'm also under the case. So if I can prove that in the court of law, ki sir, my consent was what? My consent was immaterial. It was immaterial information. Now tell me, what the four things you have to prove in the court of law? Yesterday I told you, everyone, that there is a misrepresentation and it was what in nature? Material in nature. But if you are able to prove that in the court of law, that my consent was immaterial in nature, then in that case, will you be held liable for the penalty? Or you will not be held liable for the penalty? You will not be held liable for the penalty. This is what do you mean by how to escape from the criminal and how to escape from the civil liability. So what is the first point? If you can prove that in the court of law that your statement of consent was immaterial in nature, no penalty will be imposed to you. Point number two, if it can be proved that till the issue of prospectus, it can be proved that till the issue of prospectus, the information provided was believed to be true, but later on it was proved, it was found untrue. Now what I am telling you the court of law is, sir, I think that up to the date of issue, I believed that information to be true. But later on, after the date of issue, I found out that information was untrue. So please, it is not my fault. Please give me a escapism from the which liability, everyone? From the civil liability. Sorry, from the criminal liability. So if you want to escape from the criminal liability, everyone, these are the 2 points you have to prove it in the court of law. Is it clear to all of you? Yes or no? These are the 2 points you have to prove in the court of law. Now, if you want to escape from the civil liability, what is the point number 1? If the consent was withdrawn before the issue of prospectus, if the consent was withdrawn before the issue of prospectus, can anybody tell me what is the meaning of that? Meaning is very simple, sir. Prospectus was about to be issued. Now I came to know that what my consent is, it is basically a untrue consent, because I did some R&D and I came to know that what my consent is untrue. Now tell me one thing, before issue of the prospectus only, I withdrawn my consent. I gave the resignation from my designation. Now tell me, will I be held guilty or I will not be held guilty? Before issue of the prospectus only, I withdrawn my consent. Everyone write in the comment box, guilty or not guilty? Tell me in the comment box, am I guilty or not guilty if I withdrawn my consent before the issue of the prospectus? Write in the comment box, not guilty. So in that case, will I be going under any civil penalty? Will I be going under any civil penalty? Answer is no. You will not be going through any kind of civil penalty. Point number 2. Prospectus was already issued and later on public notice was given. Now let's say for example I am the genuine person. I did not know that ki my information is untrue. I did not know that ki my information was untrue. But when the prospectus was issued, when I saw that my information was found out to be untrue. Now the problem is I have not withdrawn my position before the issue of the prospectus. The prospectus is already issued now. Now when the prospectus is already issued and my consent is there in the prospectus, what should I do so that I can tell to the people ki don't believe on my information? I went to the newspaper advertisement and I gave a newspaper advertisement saying that कि please do not rely upon my information given in the prospectus at this particular page. So tell me, did I give a public notice? Did I do a good thing for the public, or did I do an unethical thing by giving a public notice? Tell me everyone. Tell me Ummel. I gave a public notice immediately कि do not believe my information, whatever I have given in the prospectus. I issued a public notice in the circulation of newspaper, one in local language and one in English language. Now tell me everyone, did I do a rightful thing by issuing a public notice?
Yes, sir.
Yes. So in that case, should I be punished, Umail? No, I will not be punished. So you can escape from the which liability? Civil liability.
So,
Third case may, how you can escape? If it can be proved that my consent was based on expert's statement. Ajay, tell me, Umail, please tell me. When you go to a doctor and when you tell your problem to a doctor, if the doctor tells you to Amma, go for an X-ray or go for a CT scan or go for MRI and all, will you question? Ki why should I go? How you
Yes.
can say that? You question or you don't question? You don't question
I will
because
question, sir.
you will not question because the doctor is the expert in his field or not? Yes, doctor is an expert in his field. You will never question if the doctor will say, take this medicine. Do not take that medicine. Will you say to the doctor, no, 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 sir, I like that medicine. That's why I will take that one. I will not take what you are saying. Will you argue with the doctor, everyone? No, we never argue because doctor is an expert in his field. Likewise, I was about to give the information and I believed upon the expert statement, Umel. I believed upon the whose statement? Expert statement. And later on, what happened? Later on, expert found out to be a untrue person. Which person? Untrue person. So tell me, Umal, I believed upon an expert. Expert was the untrue person. Now tell me, is it my fault? Or it is not my fault? It is not your fault. Now my question is very simple. Suppose one case is going on in the court of law. One case is going on in the court of law. Obviously, you will hire the advocate to fight your case. Now tell me, when you are hiring an advocate, whether the CA is an expert or the advocate is an expert when it comes to legal advice. Advocate. So whatever the advocate will say, Arnachalam, please tell me, do you have to follow whatever the advocate will say?
Yes, sir.
Yes. Will you question his integrity or expertise?
No, sir.
No. The same is the case here. I, as a promoter, gave the statement, but I gave the statement on the belief of an expert. Expert was an unfaithful person. Expert was the untrue person. If I am able to prove that in the court of law, will I be punished? Answer is no. I will not be punished. So, are you all able to understand Okay, what are the 5 cases under which you can escape from the criminal and civil liability, everyone? Yes or no? So these are the 5 cases which they may ask you in the examination like this. Okay, Mr. Promoter was guilty of giving the misleading information in the prospectus. But Mr. Promoter is a very genuine person. In how many ways he can escape from the civil or criminal liability? They may ask you together one question, or they may ask you a single question on civil liability or single question on criminal liability. I hope all of you will be able to write these 5 reasons. Remember one thing, 2 reasons to escape from the criminal liability and 3 reasons to escape from the which liability? Civil liability. Did you all understand what I said, everyone? Write in the comment box, CC, if you all understood how you can escape from the criminal liability and how you can escape from the civil liability. If all of you understood, please write in the comment box, waiting for your reply.
Yes,
Okay,
sir.
very nice. So these are the various things. And let me tell you one thing, when you are talking about the expert, remember one thing, you are putting a huge allegation on the expert. You have to prove 3 things in the court of law about the expert. What is the first thing? Sir, I believed expert because expert was a competent or incompetent person. Tell me, Umel, why do you believe an expert? Because expert was a competent or incompetent person? Competent person. That is the first thing you have to prove in the court of law. Expert also consented in prospectus. What is the second thing you have to prove in the court of law? Expert also consented in the prospectus. So my confidence on expert grown more. Because if he is also giving the consent, I will also give the consent like that. And expert has not withdrawn it. Acha, tell me, Umyal, if the expert has withdrawn its consent and I have not withdrawn my consent, then in that case, do you think that the court will give me a case in my favor? Tell me.
No, sir.
No.
No.
So it means what are the 3 things about the expert I have to prove in the court of law? Sir, I believed the expert because expert was a which person? Competent person. He also consented in the prospectus and expert has not withdrawn it. So I thought expert is a genuine person. So I believed the expert and gave the opinion. Later on, I found that the expert is an ingenuine person. He was a fraudulent person. So sir, please give a sorry to me and I will not do it anything like this ever again in the future. So you can escape from the civil liability. Did you all understand this concept? Yes or no?
Yes, sir.
Yes. Now let us wind up this chapter called prospectus with the last topic. What is the last topic we have? Section number 36. What is the last topic? Section number 36. What is the section number 36? Section number 36 talks about inducing. What is the name of the section? Inducing or motivating someone to invest his money. Now listen to this point very, very carefully. So everyone, please tell me, do you think that I am an expert for you right now in the subject of law and auditing? Yes or no? Yes.
Sir.
Yes, sir.
Whatever I will tell you, you will all believe me because you all are comfortable with the classes. Whatever the things I will tell you, you all will believe me. Whatever the sir is saying, everything is true and fair, right or not? Let's say, for example, there is one person called A. This person called A was having 1 lakh shares of X Limited. He went to the another person called B, and this A told to the B that B by X Limited shares from 500, it will go to 1000 rupees per share in the next 1 week. Now tell me, are you showing him the profits, double the profits in the next 1 week or not? Yes, but from inside, A already knew that it was a wrong information. It was which information? Wrong information. Rather, X Limited price is going to go down. What is the actual information? X Limited price is going to down from 500 to 100. Can anybody tell me why A told a lie to the B? Because A, he's having how many shares, everyone? 1 lakh shares. If he will hold the 1 lakh shares and from 500 the price will go down to 100, whether he will lose 80% of his money or not. Tell me, if A will keep on holding this 1 lakh shares, whether he will lose 80% of his money? Yes. So A told a lie. A told a lie to B. What A told to the B? Buy the shares of X Limited. From 500, the share price will go up to what? 1000. Are you getting the point? Now tell me, did he tell him the truth or did he tell him the cheated information? Did he tell him the truth or did he tell him the fraud information? He told him the fraud information. Believed A, B believed on A, B believed on A and bought, B believed on A and bought what? Bought 1 lakh shares from A. Now tell me one thing. Ultimately, B made the profit or B lost the money?
Lost.
B lost the money. But on whose advice?
Yes.
A's advice. So who induced, who motivated whom to invest the money?
A motivated B.
B. So tell me one thing, whether A is a fraud person or not?
Yes, sir.
Yes. So what is the fraud person's penalty, everyone?
447.
Section 447. This is what section number 36 is saying. So if you induce any person, if you motivate any person to invest their money by giving them the fraud information or cheated information, then in that case, what will happen? In that case, you are guilty of fraud and you will be penalized under section 447. So if the B will make a complaint, then the A will be behind the bars, will be penalized under section 447. So how we are going to write section number 36? Now see, if any person, this is how you have to write, if any person gives deceitful, what do you mean by deceitful, everyone? Wrong, false, or fraudulent information to another person, inducing or motivating the other person to enter into contract of buying, selling, underwriting, or subscribing of securities. Making money on volatility of markets. Contract of granting credit facility to a wrong person. In all these cases, such person doing fraudulent act shall be punished under section. Tell me, everyone, shall be punished under section
447.
447. Now, what is another way by which they may ask you this question? Now, let's get this example. Now, there is one A Limited. A Limited applied 6 times loan. A Limited applied 6 times loan to SBI. SBI always rejected their loan. SBI always rejected their loan. A Limited went to Mr. Raman, who is a practicing chartered accountant. So Mr. Raman promised that I will take 10% commission I will sure that ki loan will be granted. Right or not? I will make sure that ki loan will be granted. Now, A Limited said, okay, we will give you the 10% commission. Mr. Raman did what? Manipulated financial statements of which company? Manipulated the financial statements of A Limited and applied to the SBI and got loan of 10 crores. Got the loan of what? 10 crores for the A Limited. Now tell me how much commission Mr. Raman earned?
1 crore.
Commission of rupees 1 crore. Now later on what happened? Later on the credit manager of SBI found out that the financial statements which are filed with ROC, do we file the financial statements with ROC under section 137?
Yes, sir.
Yes, and the financial statements which are filed with whom? SBI. Both are same or both are different? Both are different. It means Raman has manipulated the financial statement to let the banker believe that A Limited is a genuine person, and due to which the banker granted a loan of what? 10 crores. When the banker granted a loan of 10 crores, Raman got his commission. So here please tell me who is the wrongful person who made the bank believe that A Limited is a genuine company? Raman. So tell me one thing, is Raman going to get punished under section 447? Yes, he shall be punished under section 447 via section number 36. Did you all understand the point? Yes or no?
Yes, sir.
Yes. So in all these three cases, the penalty will be 447. With that, our topic called prospectus is over. I hope all of you understood a lot of things about the prospectus, everyone. I hope you all of you understood the all concepts of prospectus. Please write in the comment. If
Yes,
you
sir.
do not have any kind of doubt, please let me know. No kind of doubt. Very nice. Chalo, now let us start with the next topic, next chapter. Very small chapter. So I'm going to merge now two chapters together. That is called allotment and private placement of shares. What are the topics I am going to attach? Allotment and private placement of shares. Now see. What is the first topic we'll understand? The first topic we'll understand is allotment of securities. Now, when we talk the allotment of securities, we have to do the two sections, that is called section number 39 to 41. What are the three sections? Sorry, three sections we are going to do. Section number 39 to section number 41 talks about what? Allotment. And we are also going to talk about what? Private placement of shares. Do you remember on the day one of this chapter I told you? What do you mean by private placement? What is the difference between prospectus and private placement, everyone? In the private placement, company chooses the 200 people to whom they want to sell the shares. Am I correct?
Yes, sir.
Yes. So that is what section number 42, everyone. Clear? So now we are going to understand allotment of securities and private placement. Now let us first understand without fail, what do you mean by allotment of securities? Now, there are so many things in the allotment of securities you have to understand, everyone. What is the first thing we are going to understand in the allotment? Point number one. Point number one. Allotment is an act of appropriation of a capital from an unappropriated capital. Now, in simple words, if I have to tell you, what do you mean by allotment is fresh issue of share capital. What do you mean by allotment is fresh issue of share capital. Are you getting the point? My question is very simple, everyone. Can anybody tell me what do you mean by OFS? I told you OFS. What do you mean by OFS? Offer for sale of securities. What do you mean by OFS, everyone? Offer for sale of securities. What do you mean by offer for sale of securities? Do you remember? In the public offer, I told you three things: IPO, FPO, OFS. Offer for sale of securities का मतलब क्या होता है? Now listen to this very carefully. There is one promoter who is already holding 50% of the shares in the company. How many shares is holding? 50%. Now he wants to sell 30% of his shares. Now tell me, is it a IPO, is it a FPO, or is it a offer for sale?
Also,
Now my question is it a freshly issued capital
No.
or it is already issued capital?
Already issued.
It is just that from promoter's pocket, it is going to go in the pocket of whom? Public. Promoters की pocket से 30% will be reduced and public की pocket में 30% will be added. Now my question is it a fresh issue of share capital or is it a sale of shares of already allotted shares?
Sale of shares of already
So
allotted
tell
shares.
me one thing, is it an allotment or not an allotment? It is not an allotment because allotment means, now read the point very carefully along with me, everyone. What is allotment? Allotment is an act of appropriation from a which capital? From an unappropriated capital. Means it is an act of issuing a capital from an unissued capital or from an already issued capital. It is an act of issuing a capital from a which capital?
unissued capital.
Unissued capital. So it means it's an act of appropriation, means it's an act of issuing a capital from an unappropriated, means unissued capital. Now, acha, let me give you the second example. Acha, everyone, please tell me, can you please tell me when the forfeiture of the shares takes place? Tell me quickly. When the forfeiture
Member
of
did not pay the
call money.
Call
Call money.
money.
Yes.
Call money.
So say for example, A Limited, Mr. A was holding 1 lakh shares of rupees 10 each, rupees 8 paid, rupees 2 unpaid. Company sent so many times the intimation to Mr. A, please pay your 2 rupees call money, 2 rupees call money, 2 rupees call money. A paid or did not pay? A did not pay. What the company did? Company forfeited this 1 lakh shares. So my second question to you is whether forfeited shares can be issued again?
Yes, sir.
It can be
Yes,
reissued
sir.
again? Yes, it can be reissued again. Now my question is, Mr. B bought these shares. Is it an allotment of security?
No, sir.
Everyone, please write in the comment box. Is it an allotment of securities? No. These shares are freshly issued to B or they were already issued shares?
It's
They were already issued shares. They were the already forfeited issued shares which are reissued back again to whom? Mr. B. Whether the company's share capital increased or did not increase? Did not increase. These 1 lakh shares were lying idle with the company which were forfeited and issued to B. So tell me, Ummiyal, is it a fresh issue of capital?
No, sir.
So for reissue of forfeited shares is an allotment or is not an allotment?
Not an allotment.
Did you all understand the meaning of allotment, everyone? Yes or no? Yes. So this is what do you mean by the allotment of securities. So what do you mean by allotment? Allotment is an act of appropriation of a capital from a unappropriated capital. Right or not? So therefore, offer for sale of securities and reissue of forfeited shares is an allotment or is not an allotment? Is not an allotment. Now, third example, everyone, please listen to me carefully. Is bonus issue and right issue an allotment? Tell me, bonus shares and right shares are issued to whom?
Existing shareholders.
But is it a fresh issue of share capital, Amma?
No,
Yeah.
sir.
no, sir.
Yes. It is fresh issue only, na? Arey, we are giving it to existing shareholder, but do I give them already issued shares or fresh shares?
Freshers.
So does it matter that ki to whom we are issuing, or what does matter ki what we are issuing? What we are issuing, that matters. It doesn't matter to whom we are issuing. Bonus share is also a part of unissued capital only, na, which we are issuing. Right share is also a part of unissued capital which we are issuing. But are we issuing them the fresh capital or not?
Yes, sir.
Yes. So yes, it is allotment. It is an allotment. What is the meaning of allotment? So far you understood. Tell me, Aarti, what is the meaning of allotment? Aarti Mani? Allotment means what? Issue of what? Fresh share capital.
Board, sir.
Issue of the fresh share capital. Now, question number 4, everyone. Till the time you people will not understand, I'll keep on giving the example. You all know sweat equity shares, everyone. Sweat equity shares, generally we offer it to whom? Directors. And to whom? Employees. Is it a allotment of security? Answer is yes.
Yes.
These are also the fresh shares. Therefore, fresh shares means what? Allotment. Did you all understand the meaning of allotment, everyone? Yes or no? So tell me, everyone, did you all understand the meaning of allotment? So what do you mean by allotment? A fresh issue of share capital is known as what? Allotment. Everyone will write CC if you all understood the meaning of allotment. Perfectly understood meaning of allotment. Please write, everyone. Yes, perfectly understood. Fine. So this is what do you mean by allotment. Now, point number 2, everyone. Sir, we understood what do you mean by allotment. So everyone, please write in the comment box. Is reissue of forfeited shares an allotment? Is reissue of forfeited shares is an
No,
allotment?
sir.
No, it is not an allotment. So is the offer of sale of securities by the promoters to the public is an allotment? No, it is not an allotment. Is IPO an allotment?
Yes, sir.
Yes, sir.
Yes. Is FPO an allotment? Yes. Is bonus shares, right shares, sweat equity shares, ESOPs, all these are allotment?
No, sir.
Yes.
Sir.
Bonus shares, sweat equity shares, ESOPs, all these are what? Allotment. They are all fresh issue of shares. Did you all understand the concept? Yes or no? Yes.
Yes, sir.
Now, who does the allotment? Who does the allotment? Allotment is always done by board of directors. Everyone, who does the allotment always? Board of directors. Sir, other than board of directors, no one in the company can do the allotment. Sir, MD can do? No. Even though he is a top level management? No. Sir, chairman? No. CEO? No. CFO? No. CS? No. Sir, any manager? Answer is no. Only who can do the allotment? Only and only board of directors can do the allotment, or by a committee if board of directors are not doing, or a by committee authorized by board. Either board will do or a committee will do, which is authorized by whom? Board of directors. So remember one thing, no one other than board of directors can do the allotment. Did you understand the rule number 2, everyone? Yes or no? So rule
Yes.
number 1, we understood what is the meaning of allotment. And rule number 2, what we understood, who does the allotment. Next point number 3. Sir, to whom allotment is done? To whom? Allotment is done to the applicants who applied for fresh shares of company. Either it can be IPO, it can be FPO, it can be bonus, it can be right issue, it can be sweat equity shares. So whenever the applicants will apply for the fresh issue of shares, the board of directors will do the allotment. Is the each and every point going inside your head? Yes or no? Yes.
Yes.
Now, point number 4, everyone. Sir, how the applicant will come to know? How the applicant will come to know कि shares have been allotted to me. Company communicates in writing to applicant via post that shares have been allotted. Did you all understand the method? Company communicates in writing. हमेशा याद रखना, company has to communicate in writing to the applicant via post that the shares have been allotted. Lost or delayed post is not company's responsibility. What do you mean by that? Sending the post is the company's responsibility. If the post is lost or destroyed in the transit, is it the company's fault or it is not the company's fault? It is not the company's fault. Company communicates you in writing to the applicant via post that the shares have been allotted. So what will happen next? What will happen next? Applicant shall surrender allotment letter. Are you getting the point? The letter which you got, applicant shall surrender the allotment letter to company, after which allotment will be made. Allotment of securities will be made. Did you get the point? Did you all understand the process, everyone? The company first sends you the letter. You have been selected. Shares have been allotted to you. You will take the printout of that letter. You will go to the company. You will show that email or post, or you will show your KYC documents. Company will take that and company will issue you the shares. Direct allotment does not take place. Did you get the point, everyone? All of you are understanding the process of allotment? Yes or no? So everyone, please tell me, what do you mean by allotment? Is allotment means issue of shares or issue of fresh share of capital? Fresh share of capital. So Arnachalam, please tell me who does the allotment?
Board of Directors
Only
or
or any committee authorized by the board.
Board of
Point number 3.
Directors.
To whom do we do the allotment? To the applicant who has applied for the shares. And tell me one thing, allotment must be communicated by the company? Yes, it must be communicated by the company in oral or in writing, Umyal?
Writing, sir.
Writing mein. If the post is delayed or lost in transit, is it the company's fault?
No, sir.
No. Applicant has to do what? Applicant has to surrender the allotment letter to the company, after which allotment of securities will be made. Crystal clear to all of you?
Yes, sir.
Yes. Now,
Yes,
so
sir.
can I say that point number 5? Please tell me point number 5. If you think that I'm wrong, rectify. Can I say that on allotment, shares and members comes into existence? Do you all agree that on allotment only shares and members comes into existence? Now tell me, when you apply for the shares, is it a guarantee that ki shares will be allotted to you?
No, sir.
No. So on allotment only share comes into existence?
Yes, sir.
Yes. So are you a member right at the time of application, or you become a member on allotment?
Allotment.
So it means both the shares and members comes into existence only on what? Allotment.
Allotment.
Yes. Did you all understand the concept? Point number 6. Yes. Point number 7. Point number 6. Allotment shall be communicated within reasonable period of time. Within what? Reasonable period of time. Allotment shall be communicated within reasonable period of time. So allotment shall not be communicated in a delayed manner. Now tell me one thing. If the allotment is communicated to you within 3-4 days or 5 days, is it called as a reasonable period of time? Yes.
Yes.
But if the allotment is communicated to you after 1 year, is it a reasonable period of time?
No, sir.
No. The allotment must be communicated within a which period of time? Reasonable period of time. Sir, point number 7. Tell me, who does the allotment? Board of directors or committee which is authorized by the board. Anybody else is allowed or not allowed?
No, sir.
Not allowed. Acha, tell me, allotment to minor is allowed or prohibited? What should I write?
Prohibited.
Prohibited. Direct allotment to the minor is not allowed. It is what? Prohibited. But I am not saying that ki minor can't become the member. Minor can become the member via transfer or transmission of shares. But direct allotment to the minor is allowed or prohibited?
Prohibited.
Prohibited. Crystal clear, everyone? Yes or no? Yes. Point number 8. Point number 8. Now, what is the point number 8? Listen to this point very, very carefully. Allotment must be absolute and unconditional. Now, Umyal, say for example, you get a post. Congratulations, Umyal. The 10,000 shares have been allotted to you. But make sure that while making the payment for the 10,000 shares, you have to buy the 2,000 debentures of the company as well. Now, Umyal, please tell me, did I put any condition while allotting you the 10,000 shares?
Yes, sir.
Now tell me, is it allowed or not allowed?
Not allowed.
Not allowed. So that's why, what is the point 8 I wrote? Read it. What is the point 8 I wrote? Allotment must be what? Absolute and unconditional. You cannot put any condition when you're making the allotment. Everyone writes super clear, 100% understood. This is called the meaning of what, everyone? Allotment of securities. I hope all the rules of the allotment you understood. So what do you mean by allotment? We understood. Who does the allotment? We understood. To whom do we make the allotment? We understood. How the allotment is made? We understood. Allotment pe who two people come into existence? Shares and members. Allotment should be communicated within a which period of time? Reasonable period of time. Allotment to the minor is allowed or prohibited? Prohibited. Allotment must be absolute and what? Unconditional. If there is any doubt, please let me know. Any doubt or no doubt?
No doubt, sir.
Now, let us understand some sections relating to allotment. First of all, let me make it very clear. There is no definition of allotment. What I told you is the meaning of allotment. There is no definition in the Companies Act. Now, the first section which belongs to the allotment is known as section number 39. Now, listen to this section number 39. Section number 39 says that allotment to be made on public offer. Allotment to be made on which offer? Public offer. Now, listen to this point very carefully. Allotment to be made on public offer means what? Listen to this point very carefully. No allotment shall be made. No allotment shall be made unless two conditions are satisfied. What does that mean? Do we have to satisfy one of them or both the conditions? We have to satisfy both the conditions. So no allotment shall be made unless how many conditions?
Two.
Two conditions are satisfied. Now question arises, sir, what is the condition number 1? Condition number 1 is minimum subscription criteria of how much percentage? Can anybody tell me?
90.
90%. If your issued share capital is not at least 90% subscribed, can you do the allotment or allotment is null and void?
Null and
Null
void.
and void. You can't do the allotment if the minimum subscription criteria of 90% is not done. Second condition. Sir, what is the condition number 2? Minimum share application money. Again repeating, minimum share application money. Now listen to this, there are 2 points. If it is a Companies Act regulation, it says that 5% of issue price. How much of the issue price? 5% of the issue price. But if it is a SEBI Act, it means I'm talking about which companies? Listed companies. It is 25% of issue price. What I'm trying to tell, at the application only, you have to pay the 25% of the issue price to the company. If the company does not receive 25% of the issue price at the time of what? Application, then in that case, allotment is allowed or null and void?
Null and void.
Null and void. But if it is a Companies Act, how much? 5%. But if it is a SEBI Act, how much? 25%. Everyone CC? Yes or no? Please write in the comment box. This is what section number 39. So section number 39 says that no allotment shall be made unless two conditions are satisfied. What are the two conditions, sir? Minimum subscription criteria of 90% and minimum share application money under the Companies Act 5% of the issue price or under the SEBI Act 25% of the issue price. Right or not? If any of these two conditions are dissatisfied, allotment is allowed or null and void? Null and void. Next point. If securities are not subscribed, at least how much percentage? 90% within 30 days from date of prospectus. If the securities are not subscribed, at least at 90% within how many days, everyone? 30 days from the date of prospectus, company shall refund total money back to applicants into their bank account within 15 days. Within how many days? 15 days. Did you all understand the concept, everyone? If the securities are not subscribed at the rate of 90% within 30 days from the date of prospectus, company has to start refunding their money back to the applicants into their bank account within how many days? 15 days. After 15 days, you all know the interest penalty. After 15 days,
15%.
yes, after 15 days, interest at the rate of 15% per annum also to be paid by the company. And you know what is this? This is called section number 39, subsection 3. What is the section number, everyone? 39, subsection 3. So whatever I have written, this is called section number 39, subsection 3. Clear, everyone? So we have to start refunding their money within 15 days. If we do not refund their money 15 days, from 16th day onwards, we have to start paying the interest at the rate of what? 15% per annum. Now, what is section number 39, subsection 4? It is saying that, because condition number 1, this is section number 39, subsection 1. This is right side section number 39, subsection 2. Section number 39, subsection 3. And this is section number 39, subsection 4. If allotment went well, can you please tell me what do you mean by went well? Both the conditions are satisfied or dissatisfied? Satisfied. 90% share securities are also subscribed. 25% of the money has been received at which point? Application time. So if the allotment went well, then PAS 3. Sir, what is PAS 3? It is known as return of allotment. What is the name of the PAS 3? Return of allotment to be filed with ROC within 30 days. Within how many days? 30 days. So in case everything went well, file PAS 3. Sir, what is PAS 3? It is known as return of allotment. With whom we have to file it? ROC. Within how many days? 30 days. Crystal clear to all of you? Yes or no? It is to be filed with the ROC. Now, what is the penalty on violation of 39 subsection 3 and 39 subsection 4. Can you please tell me what is 39 subsection 3, everyone? Refund of money within how many days? 15 days. And what is 39 subsection 4? PS3, return of allotment to be filed with ROC within how many days?
30
30
days.
days. So if you violate, means you took more than 15 days. Already interest penalty at the rate of 15% per annum company is paying. Am I correct? But along with that, you have to pay the penalty also. Sir, what is the penalty? So if you violate section number 39 subsection 3 and section number 39 subsection 4, that is above two sections, then in that case, per day, ₹1,000, subject to maximum of ₹1 lakh. Can you tell me what is the meaning of that? Every day of delay will charge you how much money, everyone? ₹1,000 per day. And the total penalty is subject to what? 1 lakh rupees.
1 lakh.
Suppose I have delayed 48 days in filing the PS3 with ROC. Total I took 78 days. So 30 days though I was allowed. How many extra days I took? 48. So each day ₹1,000, subject to the maximum of.
1 lakh.
But what if I took 148 days, Arun Prasad? So it will be 1,48,000. But what is the maximum penalty?
1 lakh, sir.
1 lakh. Clear, everyone? Perfectly understood? So this is what brings an end to your meaning of allotment. Now, we started from here. What do you mean by allotment? And we ended up here. So this is what the point number 1, point number 2, point number 3, 4, 5, 6, 7, 8. 8 के बाद we went into section wala side. Allotment cannot be made if the two conditions are not satisfied. Any of the two conditions are not satisfied. Then if it is not subscribed at 90%, you have to start refunding the money within 15 days. After 15 days, so remember, interest penalty is different and this penalty is different. Just now we have done. Interest penalty is company. It is not a penalty. It is just the company is paying the interest. Because you will treat that ki their money was lying with the company in the form of loan. Can I say that? Ki company was having the money of the applicant as a loan. So on the loan, you are paying 15% interest. But if you violate, if you delay more than 15 days or more than 30 days in PS3, then in that case, this is a penalty. What is a penalty per day? ₹1,000 and subject to the maximum of 1 lakh. This is called section number 39. Now, next section, everyone, section number, chalo, before going to section number 40, let me tell you, in 2021 January exams, yes, in 2021 January exams, in your law paper, they asked you this question, explain return of allotment. Now tell me, what is the form number I told you?
Please.
PS3. To be filed with whom? ROC.
ROC.
Within how many days?
30 days.
30 days.
So now they are asking us to explain this. Okay, what is this PS3? Now listen to this very carefully. Company generally file PS3 when the allotment is finished. When the allotment is what? Finished. There are two cases in PS3, everyone. If it was bonus shares allotment, if it was whose allotment? Bonus shares allotment. If it was a bonus shares allotment, then there is one rule. If it was other than
Bonus issue.
bonus issue. Right, everyone? If it was bonus issue or if it was other than bonus issue. Now, if it is a bonus issue, obviously we have to file PS3 with whom? ROC within 30 days. PS3 we have to file with ROC within 30 days plus ordinary resolution copy authorizing company to issue the which shares? bonus shares. So remember one thing, whenever we issue the bonus shares, company has to pass a which resolution? Ordinary resolution. And what do you mean by ordinary resolution, Arun?
50%.
Yes, majority. Yes, majority. Ordinary resolution means majority, yes. Yes. Okay? This is what we mean by ordinary resolution. So this is the only formality. So when we are going for the bonus allotment, you have to file PAS3 with the ROC plus OR copy authorizing the company to issue the bonus shares. That is only you have to file along with the PAS3. But when we issue allotment other than bonus shares, so first point, we are going to issue PAS3 with whom? ROC. Within how many days? 30 days. Plus 4 attachments we have to do. How many things we have to attach now? 4 attachments. Now tell me on the left side how many things we attached? Only one. That is called OR copy. But in case of other than bonus issue, we have to attach how many copies, everyone? 4 copies. So what are the 4 copies? Point number 1. List of allottees. What is the point number 1 we have to attach? List of allottees. Sir, what do you mean by list of allottees? Now tell me one thing. To whom you have allotted the shares, that list we have to file with whom? ROC. Sir, what is there in that list? Name, address, PAN number of allottees, then occupation, type of security, all this, number of securities, all this information will be given in the list of allottees. Did you all understand the point, everyone? So what is the first document we are filing? List of allottees along with the PAS3. But we have to attach 4 attachments or 1? 4. So what is the first one we are done with, everyone? Write in the comment box. What is the first one we are done with? List of what? Allottees we are done with. Now, Acha, can anybody tell me, is it necessary that shares are always issued for consideration of cash or sometimes a consideration other than cash?
Other than cash.
Let's say for example, Mr. A is there. He has been allotted shares worth rupees 5 crores. So how many shares allotted to him? 5 crores worth of shares allotted to him. But Mr. A is saying, I don't have the money of 5 crores. But he does not want to lose this opportunity. But Mr. A is having a building whose value is how many crores? 5 crores. Can Mr. A give this building to the company as a consideration for the 5 crores worth of share? Write in the comment box, everyone.
Yes, sir.
Quickly. Yes or no?
Yes.
Yes. So he sold this building to whom? Company. And got what in return? Shares.
So,
Now tell me, was it a consideration of cash or a consideration other than cash?
one cash.
Other than
Yes. So cases where shares were allotted for consideration other than cash. So what we have to submit? We have to submit contract papers or agreement papers. Now obviously ROC will ask you the contract papers and agreement papers or not. On what basis you have sold the shares to that allottee? Show me the contract of sale of paper. The company will show, sir, this is the building he has sold to us. This is the contract paper. Did you all understand? Yes or no?
yes, sir.
Cases where the shares were allotted for a consideration other than cash, what you have to submit, everyone? Contract papers or agreement papers. Now the question is, think logically, Arun Prasad. Please think logically. Do you believe Mr. A if he says that his property is 5 crore rupees? Are you going to believe him blindly?
No, sir.
So at that point of time, don't you think that you will hire a registered valuer who will value the property and he will give you the report ki whether the actual value of the property is 5 crores or not.
Yes, sir. I'll check with
So it means also attach copy of report given by whom? Registered valuer. What is the name of the person?
register value.
So registered valuer will certify ki whether that consideration other than cash was suitable consideration or justified consideration or not. Did you all understand? Yes or no?
Yes, sir.
Yes. 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 Now, point number 4. What is the fourth document last? What if contract or agreement is not in writing? Suppose you have not entered into any contract or agreement in writing, but ROC will ask a proof or not. Now we don't have the contract, we don't have anything in writing, just person said this is my building, you bought it. So now tell me, do you have to satisfy ROC or not? Yes, it was a genuine deal. So now what we are going to do, we are going to submit affidavit. We are going to submit. Anybody knows what do you mean by affidavit? Stamp paper पे. We are going to submit affidavit which is stamped with stamp duty under Indian Stamp Act. Can you please tell me Indian Stamp Act 1899 to be treated as instrument. Are you getting the point? So when you don't have the contract papers in writing, then what you are going to file with the ROC? You are going to file an affidavit which is stamped with the required stamp duty as per the Indian Stamp Act 1899 to be treated as an instrument. So these are the 4 documents you need to file with the return of allotment if it is an allotment for the shares other than bonus shares. But if it is a bonus shares, everyone, how many things you have to attach? Only 1. Other than bonus shares, 4. Did you all understand the concept? Yes or no?
Yes, sir.
Yes. So that brings an end, everyone, to our allotment ka section number 39. Are we ready to do the section number 40? Are we all ready to do the section number 40?
Yes, sir.
Yes. Now listen to the section number 40. What is section number 40? Listen to this very point carefully. 39 is over. Now section number 40. What does the section number 40 says? Trading permission from RSC. What is RSC, everyone? Recognized Stock Exchange. Now my question is very simple, everyone. Once the shares will be issued in the IPO and FPO, whether your shareholders, whether your members would like to do the trading of their securities in the securities market or not,
Yes, sir.
in NSE, BSE. For that, do you have to go for the listing of the securities with the NSE or BSE or not?
Yes, sir.
But are you going to go for listing after public offer, or you are going to apply for listing before public offer?
Before that. But
Very nice.
Yeah.
No. You are going to get listed after. But do you think that on the spot NSE, BSE will give you the permission? No. You will be listed after the public offer, but you have to apply it when? Before making the public offer. Because listing minimum takes 10 weeks, everyone. How many weeks it takes? 10
days.
weeks it takes to take the permission. So can I say that approximately 2.5 months? Yes or no?
Yes, sir.
Yes. So remember one thing, you apply for listing before public offer. I'm not saying that you have to wait for the prospectus. In the prospectus, you will write कि I have applied for the trading permission. But trading permission will only be granted once your allotment is done. But it doesn't mean that after allotment you will apply. You have to apply before making the public offer. Did you all understand the point or not?
Yes, sir.
Yes. So point number one is saying, what is the point number one is saying? Before making public offer, company shall apply for trading permission for securities in one or more recognized stock exchanges. Did you understand the point number one? Before making any public offer, what they're saying, before making any public offer, you have to apply for trading permission for securities in one or recognized stock exchange. So my question to all of you is very simple. Can I go for a multiple listing? Can I list my share at NSE and BSE at both the stock markets?
Yes, sir.
Yes. And listen to this carefully, which I'm saying. If one of the stock market rejected your permission, your all permissions, all other stock markets will also reject it. It means once rejected, all rejected. Are you understanding the rule?
Yes, sir.
Let's say, for example, I applied for 4 recognized stock exchanges. Out of 4, 1 has rejected. It means remaining 3, even they accepted. Rejection is going to prevail over what? Acceptance. It means all 4 are rejected. The one rejection means all are rejected. Did you all understand the point? So I'm going to write here one rejection by any RSC is equivalent to all RSC's rejection. Is it crystal clear, everyone? Write the word CC in the comment box if you all understood the point number 1 in the section number 40. Yes? Quickly, waiting. जल्दी से लिखो भाई, बहुत टाइम नहीं है अपने पास. Everyone written? Yes. चलो. Now let's understand the next point. What is section number 40? Subsection 2 is saying. Subsection 2 says that now, do we have to wait for the trading permission to come, or I can issue the prospectus?
Issue the prospectus.
Yes, issue the prospectus, but name the RSCs. Name the RSCs where permission is applied. Are you understanding the point number 2? Ki prospectus you issue, no problem. But please name the recognized stock exchanges where you have applied for what? Permission. So that people will come to know that ki after the allotment, their securities are going to be. So that they will come to know that ki after the allotment, their securities are going to be listed in NSE or BSE. Do they deserve to know or not?
Yes, sir.
Yes, so issue the prospectus, name the RSCs where the permission is applied. Point number 3, very important point. The total money received, listen to this point very carefully. The total money received by the company shall be kept in a separate bank account. In a which bank account? Separate bank account. You can't keep the money of the applicants in your bank account. The total money received, not even a single rupee allowed extra. Total 100% money. Suppose LIC ka IPO yesterday I told you 22,000 crores or not? Yesterday did I show you the LIC ka IPO 22,000 crores or not?
Yes, sir.
Yes, into it was 3 times oversubscribed. It means how much money they might have received? 66,000 crores. Are they allowed to touch that money?
No, sir.
No, money has to be kept in a which account? Separate bank account. It can be utilized only for 2 purposes. What are the 2 purposes? Now tell me, when the allotment is allowed, when the minimum subscription criteria of how much percentage is over?
90%.
Yes, so it can be utilized for two purposes. What is the purpose number one? Allotment adjustment. What is the purpose number one? Allotment adjustment. If the allotment is over, you can adjust this money with the allotment money and final call money and application money. No problem. You can touch it only when the allotment is over. Plus, what if the 90% criteria is not fulfilled? What will happen? Refund. Within how many days, everyone? 15 days. If after 15 days, how much penalty?
15%.
So it means you can use it either after the allotment or you can use it directly for the which purpose? Refund purpose. अगर मान लो तुम्हारा 90% criteria is not fulfilled, do you have to refund the money or not?
Yes, sir.
So from the same bank account, you have to start refunding the money to whom? The applicants, to their bank account. But are you allowed to touch the money?
Yes, sir.
Not allowed to touch the money. You have to refund from that account back to whom? The applicant's account. When you are allowed to touch the money only if it is 90% criteria subscribed. Did you all understand this concept, everyone? या तो वो allotment adjustment के time पे touch होगा or you have to refund it right from this account. It means company is not allowed to touch even a single rupee till the time 100% allotment, 90% criteria is not fulfilled. Did you all understand the concept number 3 in the section number 40? Yes or no? The total money received shall be kept in a which account? Separate bank account to be utilized only on the case of allotment and refund. Everyone CC, please write in the comment box so that I can move to the point number 4. In the point number 4, we are going to understand, sir, is there any penalty? Yes, there is a penalty on violation of section number 40. Now tell me, what is section number 40? Point number 1 may be understood कि after making the public offer or before making the public offer you have to apply? Before making the public offer you have to apply. What is the point number 2 may be understood? कि don't wait for the permission to come. Just issue the prospectus and name the recognized stock exchange. Say that we have applied for the permission. Point number 3 what we understood कि amount is required to be kept in a separate bank account to be utilized only for the allotment adjustment and refund purpose. So if you violate any of these 3 points, that is called violation of section number 40. Then what is the penalty, everyone? Look at the penalty. Company ka penalty minimum 5 lakhs. What is the penalty on the company? Minimum 5 lakhs, maximum 50 lakhs. This is minimum and this is maximum. So minimum 5 lakhs, maximum 50 lakhs. And not only that, every officer in default also will be penalized. Minimum 50,000. Minimum how much thousand? 50,000. Sorry. And maximum 3 lakhs. So I hope you all understood the penalty on violation of section number 40. Yes, so it is minimum 50,000, maximum 3 lakhs. And the penalty on the violation of section 40, it is minimum 5 lakhs, maximum 50 lakhs. I hope all of you understood section number 40. If anyone is having any doubt, please ask me immediately. If no doubt, write the word ND so that I can take you to another 2 points which we have to cover in section 40. Please write ND if you all understood. Quickly waiting for all. Let me know. Very nice, very nice. So let's move ahead. Sir, so 4th point one more time, sir, explain. 4th point. 4th point is if you are doing violation in any of the 1, 2, 3 points. Suppose you did not make a application for trading permission before public offer, or suppose you did not name the prospectus. In the prospectus you did not name the RSCs where you have applied, and suppose you are trying to utilize that money which is not allowed to be touched. Are you doing the violation or not? Yes. So if you will do any of the 3 points ka violation, there will be a penalty. On the company, how much penalty? It is minimum 5 lakhs, maximum 50 lakhs. And on the OID, minimum 50,000, maximum 3 lakhs. Is it clear? So if you do any violation in the first 3 points, point number 4 is going to penalize you. Yes. Please write yes if you all understood. What is his name? Yes, okay. Okay, what is your short name by which I can call you? Can I call you Thanga? Yes? Yes. Great. Mari. Okay, Mari is better. Sure. Now, let us understand next point, everyone. The next important concept which you have to learn is known as irregular allotment. What is the name? Irregular allotment. Now, everyone, you have to answer me this. What do you mean by irregular allotment? Which went according to the law or which went after breaking the law?
After breaking the
Yes, it means it was not a genuine allotment, it was an irregular allotment. Now, I will give you a very simple hint. If this question comes in the examination, you just have to remember 4 sections. How many sections? 4 sections. Violation of any of 4 sections. Violation of any of these 4 sections is called irregular allotment. Very easy to remember. Violation of any of these 4 sections is known as irregular allotment. Sir, what is the section number 1? Section number 23, section number 26, section number 39, and section number 40. If you are issuing a prospectus, if you are doing the allotment by violating section 23 or section 26 or section 39 or section 40, then in that case, all the allotment done by that company will be treated as irregular allotment. Is it correct, Mari? Yes or no? Perfectly understood? Now question is, sir, what is section number 23? Section number 23 says that allotment done without issuing prospectus. Can anybody tell me, can you do the allotment without issuing the prospectus? Can you make a public offer without issuing the prospectus?
No, sir.
No. So you made a public offer, but you did not issue the prospectus. Or you issued the prospectus, but orally, not in writing. Are you violating section number 23, which is a beginning of our this chapter?
Okay.
Yes or no? So allotment done without issuing the prospectus or all provisions of section 23 violated. So it will be treated as what? It will be treated as irregular allotment. Clear, everyone? Yes. Now question is, sir, what is there in section number 26? Do you remember section number 26? I told you contents of the prospectus. Part A, Part B, Part C, Part D. If contents of prospectus are not as per section number 26, and tell me one thing, is prospectus required to be registered with ROC?
Yes, sir.
Yes, prospectus not registered. Can I say that I'm writing negative of these sections? Yes,
Yes.
negative of this section is nothing but called which allotment? Irregular
Irregular.
allotment. So prospectus not registered with whom?
irregular.
ROC.
Hey, RO.
Yeah, prospectus is not registered with whom? ROC. Right or not? And next point, consents were not included. What were not included? Consents were not included properly. So all these are the violations of which section? Section number 26. So what we are going to call it as? Again, we are going to call it as irregular allotment. I hope all of you are understanding perfectly. Section number 39. Just now we have done 39 and 40. Can you please tell me, can you do the allotment if the two conditions are not satisfied? What is the condition number 1?
5%
Minimum subscription criteria fulfilled or not fulfilled?
not
Not fulfilled. Minimum application money received or not received?
not received.
Not received. no refund made within time. And tell me one thing, did you file PAS3 with the ROC within 30 days? No PAS3 filed with whom? ROC. If you do any of these 4 violations of section number 39, in that case also you are going to be treated as irregular allotment. Crystal clear? And last but not the least, just now we have done section number 20. So tell me everyone, negative of section number 40. Please tell me the negative of section number 40.
Penalty.
No, negative. Did not
Mm.
apply for trading
Trading
permission. You did not apply
Trading
for trading permission. You did not apply for trading permission. Tell me the second point ka negative.
did not
Yeah, did not name,
name
not
in
named RSCs in prospectus, right or
prospect-
not? And last one, did not keep the money in a which account? Separate bank account.
separate bank
Did
account.
not keep money in
Separate
separate bank account. So in this case also, it will be treated as irregular allotment. Everyone will write CC if you all understood the concept of irregular allotment, my friend. Please write the CC so that I can move to the next part. This is what do you mean by irregular allotment, everyone. Simple. If this question will come in the exam. Now tell me everyone, frankly, please tell me, give me your small feedback. Are you understanding the law in a perfect manner like a butter inside your head? Is it going like butter?
Yes, sir.
Is it
Yes,
looking
sir.
is it looking easier now? Yes. Remember
Yes,
one thing. Whenever you have
Yes, sir.
to learn the law now, remember to learn the law like a story. The always you should do it in a sequential manner, story mein. So we are going from one section to another section, one section to another, because all the sections are connected with each other. So go like a story. If you will learn the law like a story now, then only that. Now we have already reached to the section number 40. So it means out of 148 sections of company law, 40 sections are already over. It means this is what brings an end to your concept of irregular allotment. Now there is only one small topic left, right or not? That is called underwriting. What is the topic left? Underwriting. After that, our next major section will start. That is called private placement. Very important. Now we are going to understand underwriting topic. What is the name of the topic? Underwriting. And remember, underwriting is also a part of section number 40. Now, what do you mean by underwriting, everyone? Underwriting is an agreement between whom and whom? Between the company and the underwriters. It is an agreement between the company and underwriters. So what is section 38? Section 38 to section number 40 are covered under allotment. So meaning, provisions, all that comes under section 38. Clear? You see, remember one thing. In the intermediate, only in the last 3 chapters, that is dividend, books of accounts, and audit and auditors, may you should worry about the sections. Remember, you should not worry about the sections in the remaining chapters. I'll tell you why. Because those 3 chapters are equally going to be the part of your auditing subject as well as in CA final. Are you getting the point? There are some few important sections where I focus, where I tell you. So do remember those sections. If you are not comfortable in remembering the sections, don't trouble yourself unnecessarily. In the intermediate level, even if you are not going to quote a section, no problem. They expect the advanced knowledge from you, not the expert knowledge. Section ka importance is very much important when it comes to what? CA final. Did you all understand? Yes or no? Arunachalam bhai?
yes, sir.
Yes. So underwriting is also part of section number 40. It is an agreement between the company and underwriters. Now what is this agreement? To help the company in raising what? Securities. To help the company in raising what? Securities, and to underwrite the securities, and to underwrite the securities in case which criteria is not met? In case 90% subscription criteria is not met. Now tell me one thing. What is the purpose of underwriters, everyone? What do the underwriters do? Underwriters enter into a contract with the company. They will tell to the company that we will help you in raising the share capital. We will help you in reaching to 90%. And in the contract, they write that if you will not be able to reach 90%, the shortfall, what you actually reached, and the 90%, we will take your risk. We will subscribe your that many securities. So tell me, Umyal, you are my underwriter. You promised me 90%. But actual subscription came only 85%. What about the remaining 5%, Umyal? Who will take those shares?
Company.
85% of the shares are already subscribed by the public. You promised me 90% as an underwriter, Umyal. What is the remaining 5%? Underwriters. Umyal, you have to buy those 5%. That is what the promise the underwriter makes to whom? Company. We will help you in reaching 90%. If there is a shortfall, then we will buy your securities. That is what the meaning of point number 3. To underwrite the securities in case 90% subscription is not met. And tell me, for that, what do they deserve? For that, underwriters deserve what? Get commission. Underwriters get what? Commission. Did you all understand the meaning of underwriting? So merge all these 4 points together and you will understand the definition of underwriters. And underwriting is an agreement between the company and underwriters to help the company in raising the securities. For that, underwriters will get the commission to underwrite the securities in case 90% subscription is not met. So example, company was ABC Limited. So ABC Limited was able to get 84% subscription. But what is our target? 90%. What is the shortfall?
6%.
Fall is 6%. Who will take this 6%? Underwriters will buy this 6%. For that, what the company will pay to them? Commission. Because they are taking the risk of the company or not?
Yes, sir.
Yes. So when we take the insurance policy, do we pay the premium to the insurance company? Yes.
Yes, sir.
Same is the case. We are paying the premium to whom? Underwriters, because they are taking my risk. I hope you all understood the concept. Now, there are some conditions to be satisfied. There are some conditions to be satisfied. Now, remember one thing. What is the condition number 1? Your AOA authorization is required. Whose authorization is required? AOA. Your article of association must allow underwriting commission. If your article of association is silent, you can't pay the underwriting commission. It means you have to first amend your article of association, include the underwriting commission ka guideline. After that only you can hire the underwriters. Did you get the point? So whose permission required, everyone?
AOA.
Permission of articles is required. Point number 2. Sir, what are the sources for payment of which commission? Underwriting commission. From which source we can pay the underwriting commission? Underwriting commission can be paid either from the profits of the company or from the issue proceeds of the company. Achha, can I say to the underwriter issue proceeds of the company? Can I say to the underwriters ki, okay, your commission is 10 crores. Let me give you 10 crores worth of shares. Can we give this to the underwriters in this way? Can we give the commission to the underwriters in the form of shares?
Yes, sir.
Yes. Can we give the underwriters in the form of flats, residential flats? Yes. There is no problem. So there is no problem. There is no problem on mode of payment of underwriting commission. Always remember this golden rule. So many times question has been asked. Company has given 5 flats of 40 lakhs each. Matlab 2 crores worth of flats to the underwriters as a underwriting commission. Is there any problem?
No.
No. So there is no problem on mode of payment of underwriting commission. And if you are paying in cash, then either you can pay it out of profits or you can pay it out of issue proceeds. Whatever the money is coming from the share capital, from that money you can take some money and pay it to whom? Underwriters. Is it crystal clear to all of you? Yes or no? Yes. Point number 3. Point number 3. In prospectus, you have to name the underwriters. We have to name the underwriters like we name the RSCs where we have applied for the trading permission. You have to name the underwriters. Then rate of commission. Then amount payable or securities to be underwritten. All this information you already have to include in your prospectus. Everyone CC, if you all understood this point, please write. Is it clear to all of you? So name of the underwriters, rate of commission, amount payable and securities to be underwritten. Everyone clear? Please write. Is it clear up to third point? Yes. Point number 4. Waiting. Quickly respond. If you have any doubt, you can ask me right now. No problem. Quickly respond in the chat box, please. I'm unable to see your chat. Let me just open it again. Yeah. Okay. So is it clear to all of you? Yes, perfectly clear. Yes.
Yes.
So name of the underwriters. Next point. Sir, how much commission we can pay? That is also the condition number 4. Now remember, if you are hiring underwriters for share underwriting, and if you are hiring the underwriters for debenture underwriting, I think all of you know this. This you might have done in accounts. If you are hiring the underwriters for share underwriting, you have to pay 5% of issue price or AOA rate, whichever is lower. You can't pay more than AOA rate. So how much underwriting commission you can pay? 5% of the issue price or AOA rate, whichever is lower. You can't pay more than 5. You can't pay more than AOA rate, whichever is lower. And if you are hiring the underwriters for debentures, it is 2.5% of issue price or AOA rate, whichever is lower. Is it clear, all of you? Yes or no? So whenever you are going for an underwriting, if you are hiring the underwriter for the shares, so 5% of the issue price or AOA rate, whichever is lower, and 2.5% of the AOA issue price of debentures or AOA rate, whichever is lower. This is a maximum underwriting commission you can pay. Right, everyone? This is a MCQ question they may ask you. Point number 5. Commission to be paid only on those shares which were subscribed with the help of underwriters. Acha, tell me, if the 50% of the share capital was subscribed due to the brand image of the company, remaining 50% with the help of underwriters, should I pay them the commission on total 100%?
No, sir.
No, I will pay them the commission only on which shares? Which was subscribed with the help of whom?
Underwriter.
Underwriters. That is what the meaning of this point. And point number 6, everyone, last point. File underwriting agreement copy. Who will demand this copy? You all know. Who is the father of all these things? File underwriting agreement copy with whom?
Okay.
Yes, with ROC. at the time of registration of prospectus. Did you all understand this concept? Yes or no? Did you all understand this concept, everyone? Let me know. Crystal clear? Yes. So this is what do you mean by underwriting commission? Clear? So that brings an end to your public offer section number 23 to 41. So complete section number 23 to 41, which talks about the which offer, everyone? Public offer are over here. Now we are left with a very important section. So I have to first do a little bit of adjustment in that. And let us do that first and then let's proceed. There is a Coimbatore, this one, and company law notes. Okay. Okay. Actually, it takes a lot of time, so I thought if somewhere else it is written, better to cut and copy paste from there. So that is a very, very important section, everyone, in front of you. What is the name of the section? What is the number of the section, everyone? Section number 42, which talks about what? Private placement of shares. Now, before moving to section number 42, you have to first understand some of the facts relating to section number 42. Sir, what do you mean by private placement? First of all, there are some things you need to clarify about the private placement. Suppose there is one company called ABC Limited. It can be a public company, it can be a private company, it can be a listed company. No problem with that. Just remember, there's a company. Now, this company wants to raise 1000 crore rupees. How much this company needs? 1000 crore rupees. Now, for this 1000 crore rupees, company is saying that I have to make a prospectus, then I have to make the contents. It means section number 23 to section number 41, all the formalities of the company law I have to satisfy. Am I correct, everyone? Yes or no?
Yes.
Yes. So this company got an idea. Okay, let's do one thing. This company selected some 200 people. How many persons? 200 persons. And it asked them, okay, I want to raise the 1000 crore rupees. Will you be interested in giving me the 1000 crore rupees? Now, those 200 people said, yes, we will be interested. Now, company said, oh my God, full relief. It means company need not go with a which offer?
Prospectus,
Public offer. I can go for what?
Private placement.
Private placement of the shares. So everyone, please tell me, did you understand the difference between the public offer and private placement? Public
Yes.
offer is an invitation to whom? Public. Now tell me, what is the advantage company here got? Advantage is कि company need not offer these shares to the public, and company need not dilute its controls to the lakhs and thousands of the new shareholders. How many new people are going to come? How many new people are going to come? 200 persons. But those 200 are also the existing shareholders of the company or not?
Yes, sir.
Yes. So is there any dilution of the control in the hands of anybody else? Or no
No, sir.
dilution? No dilution. So some companies do not want to go under section number 23 to section number 41 ka formalities. So some companies go for what? Private placement of securities. They go for what? Private placement of securities. Is it clear to all of you? Yes or no?
Yes, sir.
Yes. So did you all understand? So private placement of security is a very beneficial method to some companies who do not want any outsider to get a dilution of the control in their hand. So in such cases, those companies who do not want any outsider to come and control the company, they would rather suggest, or they would rather prefer a private placement of securities instead of what? Public offer. So tell me, in which case public selects you and in which case you select a public?
In private placement,
In private placement,
Company said
in the
right.
private placement, you select a company. You select the people. But in the public offer, public selects you. Am I correct or not?
yes, sir.
Yes. So this is called private placement, everyone. Now let us understand. Now see, what is the point number 1 written in the above? Please read, everyone. An act of offer or issue of securities to a which persons, everyone? An act of offer or issue of securities to the which person? To a selected group of persons. Otherwise, then public offer is known as which placement? Private placement. So when I make an offer to the group of people who are other than the public offer. So when I selected the 200 group of people to whom I want to offer the shares. That is called private placement. It means no one will come to know about this offer, because am I doing any advertisement?
No.
Am I doing any marketing?
No, sir.
Am I hiring any underwriters? No,
No.
no one I'm hiring. Slowly, I just send 200 letters to these 200 people. If they will say yes, I'll raise the 1,000 crore rupees from these people. No one will come to know that I have raised the share capital. Is it clear, all of you?
Yes, sir.
Yes, everyone. This is what do you mean by which kind of placement? Private
Right.
placement of securities. Did you get the point? Yes.